Today, we get into part one of the Weldon-Angelos Justice Act, which is 151 and 152. And under the umbrella of ending mass incarceration, we've got police reforms, prison reforms, and prosecutorial reforms. And so the Weldon-Angelos Justice Act is about those prosecutorial reforms. We dealt with the war on drugs at our last session, and today, Section 151 clarifies certain offenses related to espionage. The Espionage Act comes from 1917. It was enacted as we got into World War I, signed into law by President Wilson on June 15th, 1917. And it's been broadly interpreted at various points. Anything that might throw sand in the gears of the war machine could be considered espionage. But recently, under President Obama, espionage took on a new form, and it was used for going after whistleblowers. People who reported on things that the government was doing that maybe the government didn't want known. And one of the first main instances of this was a man named Thomas Drake. He had criticized through the chain of command the Trailblazer program, which for the NSA was using to track cell phones and emails. And he complained about privacy and management problems. And in 2010, this senior executive with the National Security Administration got charged under the Espionage Act, Section 793E. And the prosecutor said, hey, we don't have to prove that the defendant intended to harm the country, which I think just demonstrates that the issue with the Espionage Act is a definitional problem. Edward Snowden, who was also working for the NSA at the time, he saw this for what it was. It was a warning to other employees and contractors with the NSA that if you blow the whistle on things that are going on here, you could be charged under the Espionage Act. And so when he realized the extent to which the NSA was spying on Americans through a variety of programs, including collecting bulk telephone data, scanning private emails, and he'd seen the Director of National Intelligence, James Clapper, directly lie under oath to Congress. Edward Snowden realized that something had to be done. He's got a great quote. He says, "I'd been looking for leaders, but I realized that leadership was about being the first to act." And so he acted. He downloaded millions of documents that were then revealed to the American people about what was being done in their names. And he was charged under the Espionage Act under sections 793D and 793A3. Now, Edward Snowden hasn't actually been, although there's been charges filed, he hasn't hit the court system. The State Department canceled his passport while he was on a plane on his way to Latin America, leaving him stranded in Russia. And so when he tried to get political asylum in other countries, the United States pressured them to refuse. And so he's been stuck in Russia since 2013. And he'll likely remain there unless the Espionage Act is amended to clarify that what he did, the actions that he took, were not espionage. That's sort of a postscript to his story. In 2010, the Ninth Circuit Court of Appeals ruled that this program that he'd reported on, the bulk collection of phone data, it was illegal. But despite the fact that it's been acknowledged that he reported on something illegal that was going on, he's still under the threat of prosecution for making that revelation. Similar to him is the case of Reality Winner, another contractor for the NSA. And in 2017, she was charged under the Espionage Act because she mailed one sheet of paper to the press showing that Russia had tried to interfere in the 2016 election. And for that, she was charged under Section 793E and sentenced to over 5 years in federal prison. She asked President Trump and President Biden for pardon, and she got ignored and finally released last June. I guess I want to just also say about Reality Winner and Edward Snowden that they were veterans. They were people who loved their country and believed in what the United States is supposed to stand for. And to charge them under the Espionage Act, to say that they did these things with malice, towards America is just absolutely untrue. The last case that I want to talk about with the Espionage Act is Julian Assange. And as the co-founder of WikiLeaks, he drew world attention in 2010. And WikiLeaks published, with the participation of Chelsea Manning, videos of American soldiers in Iraq shooting 18 civilians, including several journalists, from a helicopter. WikiLeaks published hundreds of thousands of field reports from the Iraq and Afghanistan war. They published 250,000 diplomatic cables showing that America wasn't just spying on its own citizens, but on our allies. And when President Obama went after other whistleblowers like Edward Snowden, he didn't go after Julian Assange because this is a different scenario. What he did, what WikiLeaks did, was publish government documents, and this is something that's protected by the First Amendment. It's the freedom of the press. President Obama recognized that, but President Trump changed course, and President Biden has continued these legal efforts to go after Julian Assange. You know, this was decided back in 1971 with the Pentagon Papers. This was a government report showing, documenting how the Vietnam War had been escalated and how the American people were being lied to about it. And so the New York Times began to publish it. When the government got an injunction against them, the Washington Post started publishing the Pentagon Papers, and then 15 other papers published parts of it. And the Supreme Court ruled 6-3 that the press couldn't be restrained. That's not what America is about. With Julian Assange, I think it's also important to note that he's an Australian citizen, and that he's being accused of breaking American laws as a journalist in another country. And this is a very slippery slope we could be going down. Julian Assange saw this coming, and he sought asylum in the Ecuadorian embassy in London in 2012. And for 7 years, he stayed inside the building to prevent the United States government from coming after him. In 2019, the police were invited into the embassy. He was arrested, and since that time, he's been incarcerated for 1,000 days in the maximum security Belmarsh prison, trying to fight his extradition to the United States, where he's been charged with 17 counts under the Espionage Act. We keep talking about the Espionage Act, and I think it's important to, what does that word actually mean? So I would like to read from Webster's New World Dictionary. Espionage. 1, the act of spying. No, this isn't, publishing documents isn't spying. 2, the use of spies by a government to learn the military secrets of other nations. None of these people are employed by other governments to try and learn American secrets. So then we're employed by our own government. Or 3, the use of spies in industry or commerce to learn the secrets of other companies. And that's not the case here. What these men and women have done is not espionage. And so Section 51 goes back to the Espionage Act of 1917 and clarifies that there needs to be a specific intent to do harm with the information that is taken. Let me share my screen here. Yeah. So Section 151 amends subsection 793A through E of Title 18. And you can see the exact language of the existing law, and that instead of the current law where it says intent or reason to believe, would require a specific intent. Same thing for subsection B. Subsection C deals with things that have previously been classified. D, again, we've already got the willfully is already in the current law, adding with specific intent to injure the United States or advantage any foreign nation. Without that intention, it's not espionage. Subsection E, this is what a couple of the cases I mentioned were charged under. Is essentially like unlawful possession, unauthorized possession of documents, and just the mere fact of unauthorized possession, they're charged with espionage. And so this amendment would clarify that it needs to be done with the specific intent to injure the United States or advantage a foreign nation. In addition to updating those provisions in the Espionage Act, we'll also update these provisions relating to how you can furnish the information and open up a way for people who want to be whistleblowers to give them another option besides going to the press. And so nothing in the section would prohibit the furnishing of that information to members of Congress, to a federal court, to inspector generals, to the Privacy and Civil Liberties Oversight Board, FTC, the FCC, or other people or entity authorized to receive disclosures. So this would create an alternative way for whistleblowers to make their concerns heard and provide documentation of the concerns or the unlawful practices without going straight to the press. Subsection D relates to testimony of purpose. And this is something that Edward Snowden has talked about with him being charged under the Espionage Act. Is you're not allowed to testify about your purpose or about the classified documents. And so this subsection would offer that opportunity, allowing someone who has been charged with an offense to testify about their purpose. Why did they engage in the prohibited conduct? And establishing an affirmative defense for a charge under those sections for any violation that was done for the purpose of disclosing to the public that it was a violation of law, or that it was gross mismanagement, gross waste of funds, abuse of authority, or substantial and specific danger to public health or safety. So if you create an affirmative defense for whistleblowing. I guess the last thing I want to say is where this language came from, and it came primarily from a bipartisan piece of legislation. I believe it was the Protect Brave Whistleblowers Act, introduced by then Representatives Tulsi Gabbard and Thomas Massie to address this sort of situation, to say that, look, doing something, informing the American people of misconduct that is going on is not espionage. The Espionage Act should require a specific intent to cause harm. And that's what this section does. And with that, Mixed Chair, that concludes my testimony for Section 151. And I'd be happy to answer any questions.
How exactly will this impact these ongoing cases?
It's intended to raise the burden of proof or make the charges, have them drop the charges if they can't meet this greater burden of proof. Trying a specific intent to cause harm, it should be difficult to prove that Edward Snowden had a specific intent to cause harm to the United States. And so prosecutors should theoretically recognize that and drop the charges. He's been in exile for going on 10 years. And well, not to say that he didn't do anything wrong, but to say he's been punished enough, and Edward Snowden should be able to come home. And so this section is intended to open the door for that.
Thank you. What about previous convictions?
So this is part of the Weldon Angelos Justice Act, this whole section. And so when we get into the next provisions about revisiting sentences, people that have already been convicted of a crime and that are currently incarcerated, there is the opportunity for people whose crimes, most specifically the drug war crimes, those crimes have been changed or eliminated. There's an opportunity for them to ask for their sentences to be reviewed. And so if someone has been convicted under the Espionage Act and we change the Espionage Act, that would open up the opportunity for them to have their sentence reviewed to see, but it wouldn't be automatic. They'd have to ask for it.